Welcome to today's deep dive. Think about this. If a city builds, a playground with a scorching hot metal slide, they get sued. It's obvious.
Right, yeah.
But for a decade, the digital playground of social media has operated basically without safety inspectors.
hmm
You just entered at your own risk.
Exactly. Which is what makes this new $375 million jury verdict against Meta in New Mexico such a massive paradigm shift. Based on the Breakin' Forbes article we're diving into today, I mean, this isn't just about a big corporate fine.
No, not at all.
It's really about the legal system finally deciding that social media platforms aren't just neutral public squares.
Right, they are products. And if those products are hurting kids or enabling exploitation, well, the manufacturer's liable.
Huh.
Okay, let's unpack this. To grasp why that $375 million number is so huge, we have to look at the exact legal threshold Meta crossed right.
Yeah, so the New Mexico jury found that they breached the state's Unfair Practices Act. And that shift from standard tech liability to consumer protection law is honestly the entire ballgame here.
Wow, so it's a completely different legal strategy.
Exactly. The state didn't just walk into court and say, like, social media is bad for mental health. They argued that specific platform features, like infinite scroll and algorithmic feeds, are engineered products explicitly designed to addict.
Making them defective and deceptive consumer goods. So going back to the playground analogy, it's not just building a playground with a rusty swing set. It's like building a playground that actively changes shape to keep you from finding the exit.
That is a great way to put it, yeah.
And all while the manufacturer pretends it's just a totally normal park.
Well, to be fair, Meta would firmly argue they aren't trapping anyone. They say they're just building a highly engaging space that people actively want to spend time in.
Right, and they entirely disagree with this ruling. I know they're already planning to appeal.
They are. But the jury didn't buy that engagement defense. They legally categorized the platform's core design as an unfair business practice, which is why New Mexico Attorney General Raul Torres called it a historic victory against putting profits over safety.
But looking at Meta's immediate appeal, I mean, it's not just about keeping $375 million in the bank, is it?
Not at all. Meta is trying to stop a nationwide legal domino effect here. Because New Mexico isn't done, they actually have another trial coming up on May 4th demanding actual structural changes to the platforms.
Structural changes. Like what? Mandatory age verification.
Yes, exactly. And stripping away encrypted communications that the state argues, shield bad actors.
Oh, wow.
It's huge. And if you zoom out from New Mexico, you see Meta is simultaneously fighting a massive 30-state federal lawsuit in California, plus individual state suits in Florida, Massachusetts, and Mississippi.
Wait, here's where it gets really interesting. I need to push back on something regarding that California case. Mark Zuckerberg actually testified. And when they pressed him on Meta's struggle to identify underage users, he said on the record, "I always wish that we could have gotten there sooner."
Right, he did say that.
But is that really a smoking gun? I mean, it just sounds like generic PR regret to me. Like, oops, we wish we were faster. How does a single quote like that actually serve as legal ammunition for these other 30 states?
Because in the context of consumer protection law, the timeline is everything.
Really? How so?
Well, if you are building a product that you know is being used by minors in a harmful way, and you admit you were too slow to implement safety measures you knew existed.
Oh, I see. That shifts the legal narrative.
Exactly. It moves it from an unforeseen consequence to negligence. This New Mexico victory proves a jury can look at those algorithmic mechanics, look at the timeline, and rule it an active consumer protection violation.
So it basically provides a tested, successful legal blueprint for the rest of the country to follow.
Right.
Wow, so this shifts the fundamental rules of the road for the entire internet. The era of tech companies self-regulating their digital playgrounds is basically over. The courts are stepping in with a caution tape.
Yeah, and those courts are going to have to make some incredibly difficult trade-off, especially regarding those demands coming in that May 4th trial. If a state legally mandates the removal of end-to-end encryption to protect minors from bad actors.
How long until the fundamental expectation of private, secure messaging completely disappears for adults, too?
That is the exact question we have to ask.
Yeah, something for you all to think about.
Yeah.
If we force the digital playground builders to rip out the privacy fences to keep the kids safe, we might just find ourselves playing in a glass house.